the first to know Nsem-Pii TV.
Jabakai Abans Mana Kingsford Bagbin at the Babetu Ejase Worsen Nelson Dafiamako MP for Saudi Atabri or no Speaker of Parliament and Afe Parliament and Ankasemu at the one Aquaco PMU Supreme Court says Supreme Court for injunction and to you Nana Dodanko Kufa the ministers now what you want say one mara Parliament na yem vetu omo ye vetu omo ya ne ngi won to na won emame ministers no Albans Mana Kingsford Bagbin edi to just say Worsen Nelson Dafiamako e de akwa akopie mu court nti yentimi ento aso so far one ya vetu no ene nipa kakra bi anaka ye be vetu omo na afi one aba hye wadwuma se no yentimi ento aso till say ye bedi asem no awie all in the name of say Jubilee House at the Krata eba efa LGBTQ bill amrashe bedwafo eye ene ho na eno na me no ka say ne Supreme Court etnas ne nya asem kotoa na yenkotie mfiri obi ene ne court correspondent ho
least I'll take you to the Supreme Court na nyamiadom yen Parliamentary court correspondent for ene. And of course, because in Nsem-Pii there was Supreme Court and nimno efa Parliament and ono akoko PMU e was Supreme Court. Nyamiadom ene na me nso me ben ho baby nti me metimi akoko PMU Supreme Court obi ekoko follow matters. Supreme Court etnase from 9:30 and then by 9:20 na court no atnase. And I think the issue na nipa bebenani di akire the Worsen Dafiamako versus the Speaker of Parliament and the Attorney General issue no and I know be any I think it was the fifth or the sixth issue Supreme Court efreno ene very interesting development but I was there Kwekwasanti was there and he will take you through Nioma a course so at least undiluted na wetimi ehu ebia watete nsem ewo baby you get the real fact of what happened at the Supreme Court and ewo hakwekwa kwa beti saying
obi nyamiadom na nso
bibi ekoye
bibi ahye
in the public gallery ewo Supreme me who send out kona ho baby
me
very interesting for obia went to me am Supreme Court no e dan the course so ene
well obi say it's here for Bekaya the 22nd yes. Speaker of Parliament deliver what was a very lengthy statement criticizing the president say or decided say anti-LGBTQ bill no onje impo na wa take decisions or because of some injunction applications that have been filed at the Supreme Court. The Speaker of Parliament at the time was clear saying he disagrees with the reasoning that the presidency had adduced in that letter. The Executive Secretary Nana Bedi Asante assigned it to the Clerk of Parliament.
Yes.
But he also based on the principle that had been laid by the Speaker of by the President to say that. And also, he has been served with a certain court document from NDC MP Worsen Nelson Dafiamako challenging the president's power to appoint certain persons and purport to reassign them to certain ministries without bringing them to Parliament. So, because of that, about 24 ministerial nominees of the president and a year before Parliament. Parliament and the Speaker of Parliament adjourned the House abruptly. Up to Parliament has been on Easter break. They have not gone back to consider those businesses.
Nipa 18 and then the Supreme Court mentioned it. The substantive application will before the court, no. Efa or more omampenyi omuye ministers dada. And omampenyi eyi won say omunko ministry foforo. Enti Kojo Kroma
Dr. Amin Adam Henry Korte the former interior minister
and Ambrose Derry.
Yeah, and then there was another deputy minister, Abdullah Abanga, and then another substantive minister. I have to check the list.
In the Omoye Nipensia,
Ekufuado, Omoye substantive ministers and deputies. The president decided say he has reassigned another ministry.
Good.
Inti Omampenyi de Krata Bre, Speaker of Parliament, communicating the decision, and it was just a communication. But say. It's here for Nsubekaya Eugene at the Krata Biba Bontain. And in that letter, Eugene had started said the president has revoked the appointment of the following ministers. But then in the same letter, the the Eugene letters are said that the president has reassigned them. And Eugene Rosen say once the president purports to revoke the person's appointments, any further reappointment or reassignment must come to Parliament because it's new. But the explanation
Worsen based that claim on the Eugene Ahin press release.
But in fact, the letter that had come to the Parliament did not have that. It was just a communication, direct communication. Say these are ministers who were serving in certain ministries. I've reassigned them.
Okay.
But he was basing his position and argument
on the press
release that had been put out by the. And in fact, this issue came up on the floor many weeks before the Speaker of Parliament adjourned the House, and he in fact disagreed with the Speaker himself, Bagbin, and said that if the Dafiamapo wanted to take the matter up to court, he was at liberty to do so.
In the Dafiamapo at the court say. Some ministers in Siena or Mampenye you want ministry for front. Now was almost signed by Parliament. My Parliament vetio. No, Moshe say be approve and I say approve. In the Supreme Court no make declaration
on that. Exactly.
And only the court.
But one of the reliefs he was seeking, and he said Parliament should be injuncted from taking any decision on the ministerial nominees about Parliament.
Yes.
Before that, the president refuses to comply with the decision, the directive that they think that Kojo and the other cohort of ministers must come to Parliament. You know? Parliament's hand must be seized from working on the 24 ministerial nominees. They are new ministries, they are new nominees, or some of them were being promoted from deputy ministers to substantive ministers. So as of them, they must come to Parliament for vetting as of responsibility. As imposed by the Constitution. And so they indeed actually came to Parliament, they were vetted, their report was presented. The only thing left was the House to move a motion. Even though
the substantive issue, no effort, some ministers in Siena area sign on but or sign file an injunction application. Say, ministers now, I'm penny power on for our Marco vetting area, no. I'm some vetting. Approval no among parliamentary trains so my assembly
substantive case in India. And in fact, when it came up on the floor several times, the majority leader and even the Speaker of Parliament at some point disagreed. But Worsen Nelson still proceeded to the Supreme Court anyway. And the court, he filed an injunction application. Of course, there's been concerns as to whether or not. At the time the Speaker of Parliament was speaking, he said he had been served with an injunction. It became clear that at the time there was no injunction application.
But at the time, Speaker Ekasai on the 22nd.
The injunction application was filed the next day.
But on him said, and it came up in court. Said 2 separate injunction applications were filed. The first one was on the 21st of March 2024. So 21st of March 2024. The second one, 24th of March 2024. And the Speaker spoke on 22nd of March. And it stands to reason, of course, a presumption. Say, then maybe the Speaker was probably aware of the application, because this is the reports of the court.
Exactly, but the Attorney General conducted a search at the registry of the Supreme Court, and the answers all came, say, at the time the Speaker was speaking, that was on the 22nd, the injunction application had not been filed. On the 21st, Worsen had filed the writs by itself, the bare writs. And one of the reliefs he was seeking in the bare writ was an interlocutory injunction. Of course, some lawyers have explained, if you are filing a substantive writ, the reliefs you are seeking cannot include an interlocutory injunction. You have to do a separate application for that. So the case had to progress. That was on the 21st. So per the search of the Attorney General, which has not been impeached as of now, at the time the Speaker of Parliament was speaking, only the bare writ has been filed and served on him, not a motion, a substantive motion for interlocutory injunction.
And what can Speaker into why the Speaker made decision to make a conversation for another matter.
And so on the 22nd, that very day at 10:15, Worsen Nelson Dafiamapo files this injunction application, and now the court moves that case will be heard today.
And no case on be here and in no one court. And your bar court clerk a ball case and then a course.
Your ball case normally what will happen in court is you have fair parties. So plaintiff will be called, the defendants will be called. Your ball plaintiff, there was nobody in court to stand up say
Worsen Nelson not
only court. The lawyers in the court.
The lawyers in the court.
Speaker of Parliament, who is the first defendant, was represented by the
first defendant, the Speaker of Parliament.
It was represented.
And a lawyer.
Exactly. He was a lawyer. He came, and then there was an officer of the Parliamentary Service representing the Speaker.
Yes.
And then the second defendant, the Attorney General, he himself was there with his deputy.
And then the deputy.
So the first order of business was that the lawyers and the plaintiff himself were not in court.
Okay.
So the clerk
for the record, no. Worsen Nelson da Fiamma upon a lawyer on record. Papo Samuado of Ado and Ado. Ni chambers ni Ado and Ado. Intina omumi enunyina will be in court.
And see, at the time, the clerk at table, one of them turned and spoke to the Chief Justice. The mics was off, but you could hear, and they presented certain record to her, and the Chief Justice was very shocked at what she had seen. So immediately she put on her mic and asked that the bailiff be called to come into court so that certain
affidavit of service.
It is a hearing notice.
Absolutely. Do a bailiff. That's how serve will be. You have to come and fail that when a proof, substantive proof say indeed service no wait me. Affidavit of service no more the chair speak Chief Justice. Who dia was on the yamsheno and okaso mumfe bailiff no ankasa manemra and a bailiff ne ba.
Into bailiff nankasa by, and it's also not a very regular scene in courts that a bailiff of a court will be put under oath to present certain facts and make certain testimonies to the court. And the bailiff was put in the box. And he swore, and then he gave certain facts to the case. And the explanation is that he actually went to the lawyer for Worsen Nelson to serve on him the hearing notice because they had filed the application. There had been a response from the Attorney General, and the court had scheduled the case to be heard today. So yesterday, Oko Ado and Ado to serve the law firm notice, and ne you be hear case or see Oko Oshia man be a friend on na. And now told him say she is acting under the express instruction of me Pakbo Samoado say. So bia the document bia brand of
case
will burn emanenge. And so the lawyer, the bailiff explains say oja documents to table no so which will be means you have been served. Service. You have been served. So some of the lawyers, the judges at the table asked those questions and those answers came on. And then the bailiff was discharged. The court took some small break to obviously reconsider the issues that had come up. But before then, the Attorney General had been on his feet to say this was what he considered to be the highest form of disrespect to any person can actually in terms of behavior towards the Supreme Court, and that the Supreme Court should assert its authority on this matter. So when the judges reclined to their chambers and came back, the decision of the court was that despite the absence of Worsen Nelson and any lawyer, the case will proceed.
But mind you, sir, before the Supreme Court ever come into conclave or what have you, no masaya about back no. Na Attorney General a pre-court no say even though plaintiff and the lawyers in the but once it established that they've been served hearing notice no. Defendant mienu nyina counsels into no fee say was asem no
and in fact he is ready to even move and
absolutely.
In fact at the first instance he described the case as just a frivolous one. The Chief Justice asked him to hold on, but he wanted him to speak to the testimony of the bailiff. So when the court came back, they decided that they were going to progress with the court case, So they first heard from Thaddeus. And it's a bit of a spectacle because
before Thaddeus Bekasano court no can say on beko ahead. Here the injunction application.
And in fact, it brings back the point you had made. Worsen had filed a second application for injunction. This time specifically targeting the 6 persons who have been reassigned. So that one was filed just about 2 days ago.
And 25th.
That one has been filed, but the court said some of the services were still ongoing, and so they were going to deal with the 21st case. Right?
And you more declare In fact, omo kwashe sa 24th
yes.
injunction application. No say
abuse of court process
and a duplicitous. In the some woman the first one in an in the omo to no train say omo concentrate on 21st day no. And now omo cast councils me no address you.
So we first said from the lawyer for the Speaker of Parliament, who is the first defendant, Tadio sorry at law, and say for Becker, Speaker of Parliament had made a point on the floor, say because of the injunction, he's not going to go ahead and hear this. The Speaker of Parliament position, as announced in court by his lawyer, was that the application was meritless, that there was no basis for the court to grant the application for injunction. Because the Supreme Court has laid out the principles, the test that you must meet for a court to grant you an interlocutory injunction, and on the facts as has been presented by Worsen in the Nsem-Pii, and the legal case he has made, he has not met the standard, and so the court should not listen to him. And so he made his position at length. And then we also heard from the Attorney General, who made similar positions. In Ransford vs. France, all the other cases are the Supreme Court of Ghana has authoritatively stated the grounds for which reason the Supreme Court will grant an injunction has not been met in this case, particularly the preponderance of the probability of what is the word? It is escaped me. In terms, if I'm to put it in plain language, between the parties who will suffer more if an injunction is not granted. And the Attorney General argued, say, the balance of convenience. The plaintiff will not lose anything if Parliament was to go ahead and approve those ministers. Because, in fact, those ministers are not even the ones at the center of all this.
Of the substantive application.
Specific persons who it is claimed said the appointment was revoked and at some point reassigned. They are already acting, and there's no real suit right now affecting them. These 24 ministers and deputy ministers have all gone through vetting in Parliament. They don't have any issue, so they should go ahead. One
interesting thing. So Attorney General he put it out in the argument, and it said to ground an application for injunction, no, you should prove to the court, say, even your substantive case, no, it will course of action. In the Attorney General argument, they say even when you look at the substantive case, Nankasa, any course of action, because again, the Supreme Court, Aka, in J.H. Service Attorney General, say a new president, now a new parliament is sworn in. So president no make appointment as I appoint nominations in the Beko Parliament. I'm a parliament I avete na omo approval. But in the life of that same parliament, no, omuntimi vetted the same person twice. I think it was a critical point. Attorney General Ay3.
Yes. So the two parties, the two defendants who were in court today, made their case, and then the Supreme Court, obviously because the plaintiff and his lawyers were not present, and they had been served that the hearing was going to go ahead, had to make a determination, and it didn't take long for the court to talk among itself. They didn't even decide to go back and come back. They sat there right there, and then the Chief Justice wrote in the note, and it was clear. The chief in the words of the Chief Justice, the application is dismissed.
It's frivolous,
and it's an abuse of the court process. So on that basis, that application for
injunction application at Supreme Court at the substantive matter before the court, no, and on the court, no, and the substantive matter, no, and the fact say Sandy Pensiana area sign when there was so Parliament vetio, and I saying was a Parliament vetio, and only the substantive matter. Matisse lawyer Godwin Edugitamaklo, Director of Legal Affairs for the